Hello, everyone. Good afternoon. I'm Tom Smith. I'd like to welcome all of you to the Fox Smith webinar to discuss business considerations in light of the current COVID-19 pandemic. We've got quite a bit of material to present this afternoon and a number of relevant and certainly current topics that we want to get through. I appreciate all of you joining us today. As you'll see, the slides are available and they will for you to review as we go through the materials. The slides will also be available shortly on our website. You can reach our website to get both the slides as well as any information about our firm and the practice areas that we deal with and the presenters today at our website, which is www.foxsmithlaw.com. So I would certainly direct you to that. We have three presenters today. One of our presenters, Bart Sullivan, is a partner here at Fox Smith. He has over 30 years experience as a trial attorney. Bart has tried dozens of cases throughout Missouri, Illinois, and the surrounding region. He represents clients in a number of matters in industries, including insurance companies on coverage matters. Bart will be speaking today about some insurance topics related to the COVID pandemic. Also presenting today is another partner here at Fox Smith, Ryan Mohr. Ryan, in addition to having a law degree from St. Louis University, also has a Master's of Science from Southern Illinois. He concentrates his practice in the areas of environmental law, data privacy, and electronic discovery compliance. In addition to being a practicing attorney, Ryan is also certified through the Association of E-Discovery Specialists. Ryan will be talking to us today about data privacy concerns in light of the COVID pandemic. And our first presenter today will be Meggie Gentzen. Meggie is also a partner here at Fox Smith. Meggie represents clients typically in employment-related matters. She counsels and defends management and employers in typically cases involving employer and employee relations, as well as discrimination claims, and represents clients and employers in administrative charges, as well as defending lawsuits throughout Missouri and Illinois. So as I mentioned, first up is Meggie, and I'd like to go ahead and introduce Meggie, who will be talking about employee relations in the COVID crisis.
Good afternoon, everybody. First, oh, my clicker's not, there we go. First, I just want to go ahead and put up the necessary disclaimer for your review, and then we'll go ahead and move right through. We have a lot of information that we're going to be giving to you today. We ask that you, of course, utilize the chat feature on Zoom to submit your questions, and then also feel free to submit any questions to our firm administrator, Sherry Hurst. Her email address is there. So today I'm going to talk to you about considerations for employers in light of COVID-19. Now, I know a lot of our clients who are on the phone probably have a good grasp of some of these things. A lot of them is going to be a reminder. Some of them are going to be some updates that we have, as well as some frequently asked questions. So just to start today, I want to remind everybody of the applicable laws for consideration in light of the COVID-19 pandemic. First, of course, is the Families First Coronavirus Response Act, which we all know went into effect at the beginning of April of this year and expires on December 31st of this year. And as you can see, it applies to private employers with 500 or less employees. There is a small business exemption available, a record-keeping requirement, and of course, a tax credit against payroll taxes. Just as my own disclaimer, I want to make sure that we all understand that this is a fluid situation. It's changing daily. For example, I even changed this PowerPoint this morning to reflect a recent Department of Labor bulletin that was issued related to childcare. So, as to the Families First Coronavirus Response Act, included within there is the Emergency Paid Sick Leave Act, as well as the Emergency Family and Medical Leave Expansion Act. And the Families First Coronavirus Response Act does not apply to healthcare providers and emergency responders. And the Department of Labor has issued guidance to even broaden that so that it includes it excludes any employee of a doctor's office or hospital, pharmacy, retirement facility. But I think it's important to remember that just because those employees may be excluded under the Families First Coronavirus Response Act, they may not necessarily be excluded under the Family Medical Leave Act. And as I mentioned, the small business exemption does apply to employers with 50 or less employees, but that's not a blanket exception. It will also require that the employer provide an undue hardship in order to qualify for the exemption. Also, I think it's important to not overlook the required documentation that an employer can ask for and should ask for when it comes to granting leave under one of these acts. The documentation at the minimum must include a signed statement containing the employee's name, the qualifying reason for leave, the statement an employee is unable to work or telework, and dates for which the leave is requested. And as we all know, there's really 6 basic reasons for applying for that leave. So depending upon the qualified reason, the other required information to include in the request would be whether or not, for example, there's a government or isolation order in place, the name of the healthcare provider advising your employee to self-quarantine. And here I think it's important that you don't necessarily have to have a note from the employee's physician. A representation from that employee will suffice, especially where physicians are inundated probably with similar requests. And then another documentation to include would be the name of a child care facility which closed, and a representation that there's no other suitable person to care for the child during the requested leave. And this quote unquote suitable person language was recently added, well, not recently, in April, was included into the Code of Federal Regulations. Unfortunately, and kind of course, that suitable person language is not defined. So this is an opportunity to really discuss with your employees who the suitable person is that can care for their employees, and also having a representation from the employee that they do not have a suitable person to care for their child. And then as to the tax credit, the documentation that I just mentioned is also required in order to receive the tax credit that is available under the Families First Coronavirus Response Act. And employers can only take that tax credit for the amount of leave which is afforded under the respective act, which is generally, as you can see under the Emergency Paid Sick Leave Act, it's 2 weeks at full pay or 2/3 regular pay. If the employer decides to allow an employee to use paid time off up to so that they can get 100%, that addition, that 1/3 wouldn't be qualified for the tax credit. Just the 2/3 of the tax credit would be, 2/3 of the pay would be eligible for the tax credit. I do want to note that just recently, actually on, I believe it was June 23rd, the Department of Labor actually announced that they're going to be releasing an online tool to assist employers in determining the leave and the pay for that leave. There's currently one for employees to utilize, but the one for employers to utilize is forthcoming. So that's something to watch for. Next, under the Emergency Paid Sick Leave Act, I think it's important to remember that there's no minimum tenure of employment. An employee walks in, has COVID symptoms day 1, then they can take advantage of this. And if the individual is quarantined related to COVID or has symptoms of COVID and is seeking a diagnosis, then they can get their regular pay for 2 weeks. There is a cap under the Paid Sick Leave Act, though, too, to remember. If you're caring for a quarantined individual or caring for your child, you can get the 2/3 of your regular pay. But under this portion of the Act, employers cannot require employees to use other employer paid leave like PTO, or if you have a paid leave policy. Of course, if you want to agree to do that and the employee agrees to do that, that's another thing, but the employer cannot outright require them to do so. Under the Emergency Family and Medical Leave Expansion Act, This is essentially an additional qualifying condition under the Family Medical Leave Act. And any leave taken under this will, of course, count against available family medical leave under the Family Medical Leave Act, excuse me. You don't get 12 weeks under the EFMLA, and then 12 weeks under the FMLA. So this act states that the first 2 weeks of the 12 weeks available are actually unpaid, but it permits the employee to take paid leave under the Emergency Paid Sick Leave Act. So essentially your employee is eligible to get pay for 2 weeks, assuming that they don't meet this cap, which is that pay cannot exceed $200 per day or $10,000 in the aggregate. And like the Emergency Paid Sick Leave Act, the employer and employee can agree to supplement the leave up to the employee's full earnings during the first 2 weeks, but you cannot require that the employee do that. However, after the first 2 weeks, the employer can require concurrent use of the employer leave, allowing them to use PTO to get up to their 100% pay. And remember that because this is essentially an expansion of FMLA, the employee is generally entitled to return to the same or equivalent position. Now, under the Family Medical Leave Act, which will always be in the background, it's still a possibility for an employee, say, who's tested positive for COVID and is having some complications from that. But in order for the Family Medical Leave Act to apply to grant your employee that leave, the employer still has to qualify. You still have to have 50+ employees within 75 miles. And your employee must also qualify so that they've worked for you for 12 or more months and worked at least 1,250 hours in the previous 12 months. And you can still take this leave, remember, for a serious medical condition of yourself or for a family member, but the time is obviously unpaid unless the employee utilizes their leave concurrently. Also differing kind of from the documentation required under the Families First Coronavirus Response Act is that the FMLA, you can still require the medical certification. That element remains in effect, not the documentation under the Families First Coronavirus Response Act. So with all of these leave policies available, it's still important to remember that there's still all these other discrimination and other applicable laws which could apply. I've listed a few of them there. Obviously, this is not exhaustive, but one of them I think in particular is our state anti-discrimination laws. As we know, the CDC recently expanded who is considered high risk. And one of the most important things to note here, I think, is that they included individuals who are pregnant. Under Illinois does provide greater protections to pregnant women under the pregnancy fairness laws, including pregnancy accommodations, really for just run-of-the-mill pregnancy issues. The ADA similarly offers protections for women who are experiencing pregnancy-related impairments. Now, moving down to the Americans with Disabilities Act, obviously within that act, there is a provision for accommodations for your own disability, but there is not a provision for accommodations for a family member with disability. And even though there's not an accommodation for a family member disability, you still want to remember that there are claims for associational disability discrimination under the Americans with Disabilities Act. Recently, we've seen that the most common reported accommodations during COVID are things like telework, leaves of absence, physical barriers, and utilizing different types of personal protective equipment. Obviously, the leave of absence can be a good option if the employee is not FMLA eligible after they've already exhausted their 2 weeks under the Emergency Paid Sick Leave Act. But really importantly, I think it's here is this ongoing obligation for our employers to engage in the interactive process and perform the individualized inquiries with your employee. Follow your normal policies, engage in that good faith kind of communication with your employees. And although we always talk about the quote unquote undue hardship element that we may rely upon to deny an employee an accommodation, Although that is a high burden, considering that we are in the middle of a pandemic, it's likely going to be easier to satisfy this hardship element, but it's still important to really just discuss and work with your employees about potential accommodations that could work. As to the Age Discrimination in Employment Act, I think it's just important to note here really that there is no accommodation provision for oneself even under the Age Discrimination in Employment Act. But even though there's no minimal requirement, an employer can still enlarge and afford benefits to their older employees. But let's just make sure we do that uniformly. This next topic, this Occupational Safety and Health Administration, there has been some significant changes recently at the end of May about this ever-changing duty to investigate for all applicable employers. OSHA at the end of May changed its position regarding investigations related to COVID exposure in the workplace. It used to be only that employers in the healthcare industry, emergency response organizations, and correctional institutions were required to determine work-relatedness to COVID exposure. However, now all employers must determine whether employees who have COVID-19 potentially contracted it at work. Now, there are certain employers who don't have recording obligations on what OSHA says is, under the Form 300, which is the recording obligation for OSHA. But we still have, even if you are an exempt employee, you still have reporting obligations for certain COVID cases. So first, the employees who are generally exempt from this recording obligation are those with 10 or fewer employees, or those in low hazard industry as identified by OSHA. And there's some great secondary sources out there and guidance from OSHA about who is considered a low hazard industry, and really as to this kind of duty to investigate. But for our employers who would technically be excluded under normal reporting obligations, here we still have a recording obligation for COVID-19 exposure that could occurred in the workplace if that illness resulted in a fatality or an employee's inpatient hospitalization, an amputation, or the loss of an eye. Now, for an employer who doesn't fall within the exemption, you'll see, I'll talk about it, you can see that third bullet point down there. It expands it to just even days away from work. And really, if you've got a confirmed case of COVID, you're going to be away from work. So really, what does this mean? What do you as the employer need to do? Well, employers are going to have to start investigating work-relatedness and the COVID exposure. So under OSHA's record-keeping requirements, COVID-19 is now considered a reportable illness, and thus employers are responsible for recording cases if you can see there's a confirmed case of COVID-19, whether it was work-related, and whether that illness resulted in the items listed there: death, days away from work, restricted work, transfer to another job. So if the employee's case is confirmed COVID, well, that's easy to establish. And if your employee is not at work because they have COVID, then really the issue is, what is work-related? And what OSHA has said is that truly the employer must make a reasonable and good faith inquiry into whether or not it's more likely than not that the employee was exposed in the workplace, and whether that exposure played a causal role with respect to the confirmed COVID case. So breaking down that legal mumbo jumbo, you can really determine whether or not the COVID-19 positive test was work-related if you have multiple cases among workers who were closely together and there really is no alternative explanation. You can also look and see if there was close and prolonged exposure to a coworker or customer even who has a confirmed case. And also look at an employee's duty to include frequent exposure to the general public, where we know there's an ongoing community transmission which remains at issue. So as the employer, what can you do to determine work-relatedness? And OSHA has said that you can ask an employee how he believes he contracted the illness. You can also discuss with your employee his in-place work and out-of-work activities, but while respecting that employee's privacy. And also it's important to review the employee's work environment. Again, OSHA has recently issued a lot of guidance on this. I think they just issued one actually again last week. So that's a good tool to look at as you kind of determine work-relatedness and COVID exposure. So next, I want to just move to some kind of rapid fire, frequently asked questions that we have seen lately. And the first is, do employers have to allow employees the telework option when the work site is reopened? The answer to that is no, absent a need for reasonable accommodation. But remember, the Department of Labor is really encouraging our employers to work with your employees. So this is an opportunity to have that open dialogue that we've discussed. Another question is, how can I inquire about whether or not an employee has COVID-19? And there's three things on the screen that you can see: reliable and accurate testing, you can take their temperature, you can ask about symptoms associated with COVID. And this is, I think, a good opportunity for employers to kind of ease some anxieties for their employees by taking the time to reiterate the policies and procedures that you as the employer are instituting relating to curbing employee exposure to the virus. I mean, consider even just sending a communication to the employees about what to expect upon arrival, whether they're going to have to take their temperature, whether they're going to have to ask questions related to the symptoms associated with COVID, and allow them to know that you have cleaning crews, that there's social distancing requirements. And I think it's important to note here too that the EOC has actually issued guidance about what an employer can do, not only for current employees, but also for prospective employees. And there it's, you can take an applicant's temperature. You can screen the applicant for symptoms of COVID after making a conditional job offer. The employer may even delay the start date of an applicant who has COVID or related symptoms. And frankly, you can even withdraw a conditional offer if the employer would need that employee to begin immediately. And to go back up to this reliable and accurate testing, obviously you can inquire as to whether or not an employee is exhibiting symptoms of COVID, but you can require an actual COVID test. That's permissible. But the guidance is that you cannot require necessarily an antibody test, because that is not considered reliable and accurate, because that is in the past essentially. And while a COVID test is permissible today in light of the pandemic, that's because exposing your employees to the virus is considered a direct threat to the health of others. It's important to remember that generally employers cannot require medical testing unless it's job related and consistent with business necessity. And finally, are employers required to notify employees if another employee tested positive? I actually just got one of these questions this morning from a client, and absolutely, you can notify your employees, but do not identify the individual. You can explain that a positive case has been confirmed and notify your employees that precautions are being taken in response, like those that we just discussed. Now, can I require PPE at the work site? Yes, of course, unless there is some other type of accommodation that an employee would need because they have some type of respiratory illness. Can an employer refuse to return to work for fear of contracting the virus? No, generally you cannot refuse to return to work, but we also have to remember that if there is a safety or health concern that an employee reports, or multiple employees come to you together to report, they may be afforded whistleblower protection under laws like OSHA and the National Labor Relations Act. And do I have to offer intermittent leave for my employees under the Families First Act? It's permissible. Intermittent leave while teleworking is permissible if both the employer and employee agree. And this applies to all of the qualifying reasons for leave under the Emergency Sick Leave Act, as well as the EFMLA. But intermittent leave from a work site is only available to care for a child who does not have suitable child care. And covered employers, according to guidance, can, but they're not required to, allow intermittent leave in less than full day increments for parents who are at home taking care of their children. But intermittent leave for another qualifying reason is not permitted for work-based employees. This is a new one that was just came out from actually from the Department of Labor. I was going to enroll my child in a summer camp, but the camp I planned to enroll them in closed. Can I still get leave under the EFMLA? And the answer is yes. They've issued this because there's growing concerns associated with caring for children, predominantly because a lot of employees, in light of the uncertainties of COVID, didn't take steps to get childcare for the summer. So summer camps, enrichment programs, those are all considered places of care, and so they would qualify under the leave. But there must be some indication that the child would have attended one of these camps had the camp not closed or altered its capacity in response to COVID. So really what you have to look at is whether or not there's evidence that the plan was for the child to attend the camp, or short of a plan, whether it was more likely that the child would have actually attended the camp. Really, a parent's mere interest would not be enough. Some of the examples that the Department of Labor said was if an application was deposited, that would be an established intent to enroll, or even if you were placed on a wait list pending reopening the camp would be sufficient. And then finally, just in consideration of the changing environment of childcare, I think it's really important for employers to talk with their employees regarding the constraints under which they are working. Consider flexible work schedules or reduced work hours, or even just adjusting deadlines and helping your employees prioritize the employee projects. So I know I've given you a lot of information in a few minutes, so I just want to highlight some main takeaways. First, it's engage in the interactive process with the employees. Have your HR representatives really talk with them about what the needs of your employee is while being cognizant of what the employer's needs are. And be consistent to the extent that you can, at least, because of the fluid situation. And it's important to remember that the Department of Labor has said in most of their guidances that they strongly encourage employers to work with their employees. I've listed some resources that are provided by OSHA. A simple Google search will give you, honestly, a list of guidance and FAQs issued by these various departments to help. And I also think it's important to remember the Code of Federal Regulations. That suitable childcare that we talked about at the beginning, for example, was not included in any of the guidance, but it was, when you drill down into the Code of Federal Regulations, was included there for consideration. And then finally, I wouldn't necessarily suggest overhauling some of your employee policies which deal with this, but consider some addendums with an end date for your leave policies and things like that. But in light of certain accommodations or additional issues that are arising with employees, you may need to still revisit your existing policies or even add some policies because you've got more employees who are teleworking. And I'm going to turn it over to Ryan now, who is really going to highlight some of these policies that are good considerations for the employers that we have.
Thank you, Maggie. So this afternoon, I'd like to discuss some of the data management considerations in light of our COVID-19 responses. And with that, I will cover certain policies that if you didn't have before, you should consider getting them now. And for those that already have those policies, they should be reviewed to make sure you're still in compliance with them if there's some adjustments you might need to make, even if it's only temporary. So what's the issue? The operational response to COVID-19 has increased our risk profiles in light of data privacy obligations. This increase is due to the rapid reaction to shelter-in-place orders, including remote work solutions that were either scaled up or wholly created for the first time. While these steps were necessary to maintain business operations, the bottom line is that we had insufficient time to prepare and a lack of opportunity to really respond to the challenge. In terms of the response, The primary focus throughout my presentation will be on the shift to remote work operations. What was the result of these changes? Well, opportunists showed up. According to the FBI, there's been a sharp spike in cyber attacks, as you can see from these headlines I've put up from April and May of this year. And how is this happening? There are a variety of methods, but in particular, there has been a significant increase in phishing and social engineering activities. This method of choice reflects the fact that each of your remote workers off-site is a potential doorway into your company's systems. So consider the systems and security you have at your office and the reasons for those systems. Now think about which of those systems your employees do not have at home. And the answer is most, if not all, of those systems. For most employees, the best case scenario is that they have a password protected Wi-Fi on their home network. Of course, that doesn't help if they've inadvertently installed malicious code. You're probably thinking, but we have software on our systems to address this issue. Then the question is, have you verified whether those off-network are still getting proper updates to that software? Also, the information your employees are saving locally, their computers may be at risk even if your company's network is not penetrated. Remember, 50 off-site employees are more likely than not 50 off-site data centers. So what's the potential impact of this increased risk? As you may be aware, the U.S. does not have a comprehensive data privacy and security law. Rather, we have a patchwork of requirements found in various federal and state laws. Our response to COVID-19 has implications that span many of these laws and increase the potential for liability. For this presentation, I'm highlighting a few laws that are more commonly impacting our clients. Due to our time constraints, I will only provide a brief update. So first, let's deal with COPA. That's the Children's Online Privacy Protection Act. This act applies to information collected from services directed at children up to 13 years old. Keep in mind this act generally applies to the operator of the service. COVID-19 has resulted in a significant increase in use of remote learning programs. As a result, those using platforms for remote learning programs should make sure they have appropriate notice and consent forms. The Federal Trade Commission has issued guidance which you should consult if you're offering such services or platforms, either online or directly. So FERPA, that's the Family Educational Rights and Privacy Act. Generally, this provides for control over access to and disclosure of educational records. If you are subject to FERPA, note the Department of Education has issued guidance in light of COVID-19. In particular, the guidance addresses application of the health and safety emergency exception to consent. For example, if threshold findings are met, you may be able to disclose to appropriate parties, such as parents or other students, that COVID-19 has resulted in a student absence if done in a way that the student cannot be identified. Note the applicability of this exception is generally a case-by-case determination, so you should develop appropriate documentation for each such instance. HIPAA, Health Insurance Portability and Accountability Act. The HIPAA privacy and security rules generally apply to covered entities and their business associates, which are defined terms within the regulations. This is a very complex regulatory framework, and a full discussion is well beyond the scope of this presentation. However, there are a couple items I would like to highlight for you today. One, multiple bulletins have been issued by Health and Human Services and the Office of Civil Rights in response to COVID-19. Those covered by HIPAA should familiarize themselves with these bulletins, which offer clarifications and some relief. For example, OCR has stated it will exercise enforcement discretion in connection with the good faith provision of telehealth, even if not strictly regulatorily compliant. Two, it can be a bit murky as to when your HR professional is performing functions for a group health plan, which is subject to HIPAA, versus employment functions. Put another way, group health plans are covered entities. If you're collecting employee health information in connection with COVID-19, you will need to evaluate this issue. You can start by asking, why are you collecting the information and to whom will or has it been provided? For example, if you're considered a plan sponsor, then there are certain restrictions on sharing such PHI outside a select group. Lastly, on these federal regulations, I want to address DFARS, this Defense Federal Acquisition Regulations. These regulations impose a cybersecurity framework on those that handle specific categories of information in connection with certain government contracts. Sorry to report that I've not located any guidance that would limit or reduce compliance with, for example, the NIST 800-171 standard in light of COVID-19. Any telework you have created will need to be evaluated within the applicable frameworks for your operations. Let's turn to state law considerations. Missouri has two laws I'm going to highlight for you. The Consumer Protection Law covers any person or entity that owns, licenses, maintains, or possesses records or data that contain personal information of Missouri residents. Similar to federal statutes, breach notification may be required for unauthorized access to and unauthorized acquisition of personal information. Also, there's a separate Missouri statute that expressly governs Social Security numbers. This statute applies to any person or entity and prohibits certain actions such as disclosing an individual Social Security number to the general public or requiring a person to transmit Social Security numbers over the internet unless the connection is secure and the information is encrypted. Turning to Illinois, HIPAA, that's the Personal Information Protection Act, covers any entity that handles, collects, disseminates, or otherwise deals with non-public personal information regardless of purpose. Breach notification may be required for unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of personal information. Note this particular statute creates a private right of action for violations and expressly prohibits any waiver of its protections. Also, we have BIPA, that's the Biometric Information Privacy Act. This covers notice, security, and policies for biometric data you may collect. The most obvious example is use of an employee's fingerprint for a time clock or to access computer systems. Note the statute also creates a private right of action for violations. Please remember that these state statutes remain in full force and effect despite COVID-19 and apply to residents of the state. For example, if you are solely located in Missouri but have employees who reside in Illinois, you will need to evaluate applicability of the statute to their information that you may collect. Moreover, some of our responses to COVID-19 may implicate these statutes. For example, increased potential for data breaches arising from telework. Or more directly, some companies are offering kiosk stations for employee check-in. These kiosks use biometric data to identify the employee prior to recording temperature and responses to the employer's COVID-19 questionnaire. Prior to COVID-19, we saw an increase in class actions filed in Illinois under its privacy laws, mostly for failure to comply with statutory requirements. I fully expect we'll see an increase in the same data privacy litigation, but it's going to rise from our lack of response in light of these COVID-19 adjustments that we've made. A few other considerations. Don't overlook your contractual obligations. It's not uncommon to find non-disclosure or other confidentiality and breach provisions in contracts. Some provisions are specific. For example, prime contractors tend to push specific provisions to their subcontractors. Other contracts may just contain a general or blanket prohibition on the release of information outside the company or the relationship. These are also concerns for anticipated litigation or pending litigation. For those who have been parties to litigation, you will recall your duty to preserve evidence. So here we're not worried so much about a breach as we are spoliation. Perhaps your usual preference is preservation in place. That option may be appropriate in the ordinary course, but that's not where we are at the moment. Ask, is preservation in place appropriate for your current configuration? For example, will it be found to be a reasonable practice if your custodians are working remotely and their systems are no longer on network and so not subject to routine backups? Worse, what if your employees are now using their personal computers to access your network? Do you have their consent to access those systems if needed to meet your discovery obligations? So let's look at some policies now that may be impacted by your remote workforce or your COVID-19 response generally. Please note, depending on your organization, you may have additional policy to be evaluated. This is just a sample of the ones most likely impacted. Teleworker or work from home policy. This policy is used to set expectations for employees working from home. Some issues will be specific to your company, but generally you should consider addressing the following categories in that policy. Who is eligible to work from home? A required schedule for availability, responsiveness to requests, availability of equipment such as computers, printers, and other things they need to do their jobs. State affirmatively that company equipment is being loaned and remains the property of the company. Expectations for physically securing company equipment and information, including printed materials when off-site. Methods to maintain file integrity at your office. A reminder to adhere to other company policies and requirements to comply with directives from IT to ensure digital security. For example, coordinating for installation of security patches. A data ownership policy. This policy quite simply defines who owns and controls company information. It may also address use and distribution of company data. There are a variety of reasons to have this policy. For example, if you're permitting employee-owned devices to be used for company business, don't assume you still have control over and access to that data. A confidentiality policy will generally identify categories of information, including customer and client information, and how each is treated and handled internally, including specific guidelines and prohibitions on disclosure. You may need to revisit this depending on your current response. For example, it may prohibit use of personal devices that you are now permitting. A privacy policy, and in this context, I'm referring to an employee privacy policy. This policy should clearly provide notice to your employees regarding the limits on the expectation of privacy when accessing company resources. For example, the remote workers you have now, you may have decided in light of that to let IT periodically scan remote devices, or you may have deployed productivity monitoring tools. You should clearly communicate monitoring of that type to your employee activities so the employees are on notice. This is particularly important when considering you may now be allowing personal devices. In addition to monitoring, your policy may prohibit disclosure of employee personal information, but depending on your COVID-19 communications, you may need to amend this policy. Bring your own device policy, BYOD. This policy addresses the issues that arise when you permit an employee to use personal equipment to access your company's information or network. If you're permitting this type of access, for example, syncing email to personal smartphones, this is a very important policy and you need to address it. Among other things, this policy should set out expectations of the company's right to access the equipment and the circumstances for such access. Unless addressed elsewhere, this policy should strictly prohibit use of third-party cloud backup solutions outside the company's control. Acceptable use. An acceptable use policy outlines the purpose for and the manner in which company assets may be used. In this context, consider remote workers whose hobby, unbeknownst to you, is illegally downloading movies, music, and software. When the employee's activities are ultimately traced, it'll be traced back to your company's equipment. Getting in front of this issue by prohibiting some of or all personal use may help avoid such situations. Consider looking at your separation procedures. Evaluate whether your remote workforce is addressed. For example, how are you going to secure return of your equipment from a very unhappy teleworking employee who you terminated for cause? You may also need to consider using specialized software solutions and a forensic consultant as reasonable steps to ensure you're protecting the company's and your customers' information and competitive advantages. Litigation holds. This is a written communication issued to custodians of potentially responsive information in response to a triggering event which is not necessarily filing of litigation. This includes, for example, a threat of litigation or when an injury occurs that may give rise to litigation. You should review your standard letter to determine whether it is adequate given your current practices. For example, you may have been convinced in light of COVID-19 in your remote workforce to deploy messaging tools such as Office Messenger, or worse, your employees are using messaging apps on their personal cell phones for company business. Depending on the litigation, this information is discoverable and must be preserved. Business continuity and disaster recovery. Generally, this plan identifies the steps to be taken and by whom in the event of a loss of access to information or interruption in business operations. For example, a total network failure, natural disaster, civil unrest, or a pandemic. If you have a plan, Is it still viable in light of your COVID-19 response? Some of your data is now remote, and perhaps more importantly, some of your response team may be as well. I want to jump to civil liability or cyber liability coverage, excuse me. My partner Bart Sullivan is going to be discussing insurance in the next section, but I wanted to highlight some special considerations. For those with cyber liability insurance coverage, your COVID-19 response may have created some potential issues for you. Consider your system is generally defined for the purposes of your policy. Did you indicate that you did not allow remote access on your application and now half your office is connecting remotely? Does the policy only respond to a breach from company-owned systems, and yet you're letting employees access your network via their home computers? These are things you need to evaluate. Also, cloud services and storage solutions are generally excluded by policies, or can be depending on who your carrier is. Did your employee who's now using their personal iPad to access your network remember to turn off their iCloud backup? If not, a breach from that iCloud backup, even though it's their personal backup, may be a breach of your information. Finally, cyber liability policies generally have some language regarding the insured's obligations to take reasonable steps to safeguard and protect their systems. Are you meeting best practices for your newly created workforce, or are other changes that you need to make in light of your COVID response? One last note before I turn the presentation over to Bart. Some action items for you. Review and create or adjust appropriate policies and procedures. Don't overlook contractual or litigation obligations when evaluating compliance. Review and address cyber risk insurance coverage as appropriate. And while this may sound self-serving, I strongly encourage you to discuss these issues with counsel at the outset of your review. There are a few reasons for this cautionary note. Adjusting these policies in a vacuum can impact other obligations, including pending or anticipated litigation. Counsel can help steer you, the project, in your decisions in a way that you don't create new liabilities. And you may also be able to shield all or some of this effort as privileged, which may further protect the company's interests. With that, I'll turn over the presentation to Bart.
Thank you, Ryan. And obviously, there are a number of types of insurance and insurance coverages that are available. Ryan just mentioned cybersecurity. Also in the workplace, obviously we have medical coverage, key person coverage. I'm going to limit what we talk about today to really three areas: business interruption, workers' comp, and commercial general liability. As a starting point, there are existing policies that cover losses associated with viruses and even pandemics. So we'll touch on some of that. But most, if not all, not all, but many commercial insurers learned from the SARS pandemic in 2003 and introduced exclusion clauses for communicable diseases, epidemics, and pandemics. Many commercial insurance policies do not provide coverage for communicable diseases, for viruses, or even for COVID-19. There were some policies as late as or as early as late last year that were already addressing that. Business interruption coverage, what is it? Typically, you think of it in terms of replacing business income lost as a result of a disaster, like a tornado, hurricanes, that kind of thing. From a virus pandemic, people in the industry are telling me there are many of those claims already made, and I expect we're going to be litigating that for the next several years. Business interruption coverage typically covers actual losses sustained by insureds as a result of direct physical loss or damage to the insured's property by a peril that is not excluded from the policy. Business interruption coverage is not usually sold as a separate policy. It's an add-on or an endorsement or part of a comprehensive policy. Business interruption coverage can also apply on a contingent basis. And the way to think about that is your business was not impacted by the tornado that just ripped through town, but your two best suppliers were wiped out, such that you're not able to build the goods that you're used to making, or you're just really not able to conduct any business. That's contingent business interruption, and that may apply in the world of pandemics. It's an extension to other insurance that reimburses lost income and expenses resulting from that type of interruption. Here's a typical business interruption clause that you'll see in many policies. Will pay for the actual loss of business income sustained due to the necessary suspension of operations during the period of restoration from the disaster or whatever it is that made you cease business operations. The suspension must be caused by the direct physical loss, damage, or destruction to property. And here's the key part. The loss or damage must be caused by or result from a covered cause of loss. So the key questions for business interruption recovery as it relates to COVID: was the interruption caused by a covered peril or event? And is coronavirus, or more specifically COVID-19, a covered peril under your BI policy? You need to check with your policy on that, or the people that you deal with in your insurance program. Workers' compensation, I'm just going to deal with quickly. It's state law based, obviously. Many states exclude for workers' comp coverage for cold or flu. That doesn't explicitly apply to COVID, although some states may issue laws differently. A number of states have already issued statements or made determinations about whether workers' comp covers COVID-19 illnesses. And this is literally changing on a daily basis. As of a few days ago, 14 states had extended coverage for COVID-19 as a work-related illness. 6 states have enacted legislation creating a presumption of coverage for some types of workers. At least 5 states offer workers' comp for first responders and healthcare providers, and I believe Missouri is now in that group. Illinois covers just about all workers, and several other states are looking to cover certain types of essential workers. Again, this is changing certainly weekly and maybe daily, so check with your state and see what it's doing on comp coverage if you need to go that way. Commercial general liability provides businesses with coverage for injury or property damage caused by the company's products or operations on site. It applies to losses from third parties, such as customers and other businesses, but not to employees. That's workers' comp. Just about all ongoing businesses have or should have good commercial general liability coverage. Key questions then are not too surprising. For it to apply, did the exposures come from your company or from within its premises? And Meggie was talking about that at length. And something else I would add with respect to asking employees about how they got their COVID exposure, another element there is, do you have a group of people that came down with exposure or tested positive all at one time or within a few days? That may be pretty good indication that something happened on site to cause the infections. Is there communicable diseases, coronavirus, or COVID-19 exclusion in your CGL policy? Whatever type of policy or coverage you have, the key questions, as you can kind of already tell, are inevitably going to be, is there a virus exclusion or other exclusion that could apply? If so, how clear is it? And is there any ambiguity in the exclusion language? I mention that because some policies added endorsements explicitly excluding coronavirus years ago after SARS, and some excluded COVID as early as late last year. And I must tell you, in the news today is information that there is another potential virus coming from Asia that could create pandemic conditions. I'm not sure whether it's another coronavirus, but this is the world we're living in. The exclusions we're talking about stems from this awareness of SARS and before that MERS, and early reports, maybe rumors, of COVID-19 in China. And you have to imagine that the insurance industry will pay very close attention to what we just talked about, the news about a potential new virus that could create these types of problems. Can you get coverage for big losses? You may have seen that the Wimbledon tennis championships were canceled for this year. They're not going to be rescheduled. They're out and out canceled. But they had the foresight at the All England Lawn Tennis Club to purchase pandemic coverage for the last 17 years. They've reportedly spent somewhere in the neighborhood of $34 or $35 million for that coverage. Was it worth it? Well, the policy will pay them $141 million this year for the canceled Wimbledon championships. About half of the club's anticipated loss, but certainly softening the blow somewhat. Not all organizations are so fortunate. USA Judo, for example, is an athletic organizing organization in this country that is tied with the Olympic movement and oversees the Olympic teams in that sport. They have coverage, COVID-19 coverage now, but it runs out on September 1st. And the organization is finding that it's going to be very difficult to get new coverage. So far, they haven't had any luck in that regard. And if you're able to find it, I would surmise that there are going to be relatively few insurers that cover it, and those that do are going to ask for premiums. Going to be expensive. A couple of policy examples. Commercial general, this is typical language that you see. The insurance isn't going to apply to communicable diseases, bodily injury or property damage arising out of the actual or alleged transmission of a communicable disease. Now, is COVID a communicable disease? I don't really know. And from what you're seeing in the earlier reports, there is debate about that. So that could be the subject of how your insurance company handles it, if that's the type of exclusion you have, or litigation down the line. But when that endorsement is attached, generally, we're finding that there's no coverage for the transmission of the coronavirus or its resulting illness. Here's a commercial property exclusion that you see. We will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism, et cetera. The virus exclusion really nails down that and is far more specific than the communicable disease exclusion. A number of states, as you may have seen, are considering legislation to cover some COVID-related liability. There are a couple of bills before Congress in the business interruption realm. As we sit here, last time I checked, none of these bills in the states or in Congress have been passed to this point, but I think many of them are still under consideration. One of the congressional bills would require insurers that offer business interruption coverage to also make available the coverage for losses resulting from any viral pandemic, forced closure of businesses, or mandatory evacuation by any government or agencies, or power shutoff for public safety purposes. The other bill that's before Congress would mandate that insurers offering business interruption coverage have to make available additional optional coverage for insured businesses covering losses that occurred because of BI due to any government order that required the business to cease its operations during the emergency, or occur in an area in which the national emergency applies and during the period of the application, so long as it's not shorter than 30 days. What's going to happen with these bills? Or what if President Trump, for example, tries to execute some sort of order requiring it? He has already spoken that he would like to see business interruption losses paid by insurers if the policies don't exclude pandemics. My guess is the Fed's going to play a role in this. The chairman of the Fed is speaking today before Congress and reportedly is ready to say he's going to continue to do what it takes to keep the economy moving. And if you start to hear noise about well, the Fed ought to back up the insurance industry on claims for business interruption related to COVID that would ordinarily be excluded, that may be the way that this comes to pass. Because if the states or the Congress requires business interruption coverage that is excluded right now, you can foresee a lot of roiling of the insurance markets, both here and internationally. So a few takeaways, pretty common sense if you think about it. Your broker ought to be able to explain your coverage benefits, exclusions, and future coverage options. I say future coverage options because, again, future pandemics are possible, and what can you do with respect to COVID, which isn't likely to go away in the next year to 2 years. Your insurer or its agent ought to be able to help you, and most insurance companies have really good information on their websites now. And again, if you have questions or want to discuss before you call your insurer, your in-house counsel or your outside coverage counsel ought to be able to help. So on behalf of Fox Smith, I want to thank you for participating today. All of us at Fox Smith are very appreciative that you took the time to join us. For attorneys who are on, we have submitted for CLE credit and we'll keep you advised. And if you have questions or feedback, please send those to Sherry or to any of us. Also, we want to remind you that we want to invite you to the Fox Smith Legal Symposium, which is scheduled to take place on October 21st. Details right now are on the website, and you'll be hearing from us on that. So again, thank you very much, and we will see you down the line.